Ladies and gentlemen, the Supreme Court of Florida.
Good afternoon. Welcome to the Florida Supreme Court. We're here today for the case of Rogers versus State of Florida. Counsel.
Good afternoon, Chief Justice, Honorable Justices of the Supreme Court of Florida, and may it please the Court. My name is Ethan Williams, and together with my co-counsel, Zoe Priello, we are representing the petitioner, Jack Rogers, in today's arguments. Out of the two issues presented, I'll be arguing Issue 1, and I will demonstrate why the lower court's decision should be reversed, as no exceptions to the Fourth Amendment apply that justify our client's violation of his Fourth Amendment constitutional rights. At this moment, would the Court benefit from a brief restitution of the facts before we begin?
Sure, go ahead.
Of course, Your Honor. Two robberies occurred on two separate days at two separate stop-and-drive gas stations in Small River City, Florida. In both instances, a 2016 Chevy Silverado truck pulled into the parking lot of the gas stations. Three individuals wearing face coverings and black hooded sweatshirts exited the vehicles, entered the stores, and proceeded to rob the owners. In total, cash adding up to over $7,000 and a box of cellular phones was stolen from the stores. In both robberies, a police officer was able to be dispatched immediately after the robbery, and witness statements and security footage was obtained by the officers. Details of the make, model, and year of the car were then broadcasted over radio to police officers on duty, and an email was sent to the police department regarding these details of the individuals and the vehicle involved in the crime. On Monday, August 29th, after the second robbery occurred just 3 days after the first, on Friday, August 26th, Jack Rogers, our client, was driving to school at 6:30 in the morning. Officer Doe, a police officer on patrol at the time, was expressly on the lookout for a 2016 Chevy Silverado that matched the description of the vehicles involved in the robberies. Upon seeing our client driving to school, she then pulled over Jack Rogers, asked for his license and registration, and then proceeded to conduct a warrantless search of his vehicle, violating his Fourth Amendment rights.
Would it have violated his Fourth Amendment rights if she had told him he was under arrest first? Or would that have been different?
It would not have been different, Your Honor, because she still did not have a warrant. And
well, but we do recognize an exception to the warrant requirement, right?
Of course, Your Honor, the incident to arrest exception, which does not apply in this case today, and neither does the automobile exception. In United States v. Ross, to address your incident to arrest exception first, actually. In order to search a vehicle per incident to arrest, an officer must have probable cause to arrest the occupant of the vehicle, and then must have probable cause to believe there's evidence of that offense of the arrest in the vehicle that the occupant is driving. In this case today, Officer Doe only was aware of the vehicle's description and of three suspects that were involved in the robberies. She was not aware of what was stolen or of, and she was specifically aware of those three individuals. When she pulled over my client, it was only Jack Rogers in the car, and it had been over 2.5 hours since that initial robbery when she pulled him over. And in this instance, in cases like New York v. Belton, officers can search incident to arrest if that arrest is valid. In this case, Officer Doe didn't even arrest our client until after she already searched his vehicle, meaning the incident to arrest exception cannot exist without the automobile exception in this case today, because both must be grounded in probable cause.
So what about the automobile exception? Why doesn't that apply?
Yes, Your Honor. The automobile exception does not apply because Officer Doe did not have that probable cause to believe that fruits of the crime are contained within our client's vehicle. In Brown v. State, it is established that in order for a vehicle to be searched under the automobile exception, probable cause is established when the search itself is believed to be fruitful. In this case, fruits of the crime would be evidence from those two robberies that had occurred hours before the stop and days before the stop.
Is that the only reason why we have an automobile exception, or isn't there sort of a concern for officer safety that animates the automobile requirement too?
I'm not quite sure I understand your
Well,
question.
what are the reasons you think that there's an automobile exception to the search warrant requirement?
Well, when the automobile exception was first established in United States v. Carroll, it was specifically established because of destruction of evidence. So when a car is readily mobile, evidence in that vehicle, potential evidence in that vehicle, could be destroyed if a police officer was not able to conduct a warrantless search immediately. However, they still must have that probable cause. In the case here, like in the case State v. Clark, is a question versus reasonable suspicion versus probable cause. When Officer Doe originally made the stop, she made the stop specifically because of the details matching the truck and my client's vehicle, meaning that the only way this stop could be legitimate was if it was an investigatory one, meaning she would have to have articulable reason to believe that this vehicle was involved in criminal activity.
Well, how do we factor in that during the stop she gets the call that provides the additional information about the license plate and that matches?
Well, Your Honor, we would argue the license plate doesn't actually give her any new information to establish probable cause. This just adds to the details that the vehicle may have been involved in the crime, which plays to her reasonable suspicion.
Is that a dangerous precedent to set with an officer? She has a truck that matches the make, model, color, dark tint. That's appearing. Now we have a license plate that matches. I mean, at what point does it become unreasonable for an officer to ignore that?
It would become unreasonable if they didn't have substantive evidence that there's fruits of the crime located in the vehicle. The question
So why isn't the time enough for that? There was a few hours that passed, but why would it not be reasonable for the officer to assume that there might be evidence of the crime in the truck just based on the limited passage of time?
Well, Your Honor, several hours have passed, and in cases that have previously set forth requirements for the automobile exception, like United States v. Ross, and within that, Chambers v. Maroney before that, they all deal with vehicles that were stopped within an hour after the initial robbery or crime had occurred. In this case, it was several hours. And even with the license plate tag that she was reported during the stop, that provides no new information as to where the truck was between those hours. And it even plays into the fact that there was only one person in the vehicle when Officer Doe made the stop, and there was 3 suspects related in the crime. So she could not reasonably connect any occupants or any items in the vehicle to the crime because there had been several hours that had passed. And so there's not enough temporal proximity to assume that there is evidence. And because you need substantive evidence, as set in State v. Hendricks and later State v. Clark, things are exceptions such as plain view exception or the eyewitness exception must play and must give substantive facts. Officer Doe did not see anything in the vehicle that could have been contraband. She didn't even know what was stolen.
What about the backpack?
The backpack, Officer Doe was informed that our client was on the way to school. This backpack does nothing but corroborate his story. There's nothing threatening about the backpack. There's nothing protruding from the backpack. And any argument made that the backpack posed any danger because a gun was involved is highly unreasonable because our client showed no threat to Officer Doe. He did not show inconvenience. He cooperated with the stop. He cooperated. The only defiance he showed to Officer Doe was when she tried to violate his rights and search his vehicle, and he insisted no, she didn't have a warrant, and she's still pursuing and asked him to step out of the vehicle and search his vehicle without a warrant.
Counsel, let me ask you this question. If we find that Carroll applies in this case, you lose, correct?
Correct. Because
And why is this case, distinguish Carroll from this case for me?
in Carroll specifically, probable cause existed there because matching description of the vehicle linked reasonable suspicion, and because officers were able to determine, because of eyewitness reports, they were able to determine that there would be evidence in the car. In this case, there's no clear connection that there is evidence in the car or that the occupant was involved.
In Carroll, was there a description of the driver of the vehicle as well?
There was a description of the vehicle, or the occupants, yes. But
go ahead.
But in this case, Officer Doe knew, in the record, it states that she knew that there was 3 suspects, and in this case, when she pulled over my client, there's only 1. So there's no connection between to arrest him, so the incident to arrest exception does not apply, and because she has no substantive evidence for plain view or eyewitness, because several hours had passed, there's no probable cause because no substantive evidence exists, and that's why we asked this court to reverse.
So what should have happened? So once she gets the license plate information, it's obvious that this is the car that was involved in the robberies, right?
Reasonably.
So what would the right thing to do have been?
The right thing to do would have to stop our client, ask for a warrant from a court, get the warrant, and then search his vehicle. She didn't do that. She had him step out of the vehicle, search the car, and then arrested him without a warrant, all without probable cause. And that's why.
How long do you think that would take?
To get a warrant, Your Honor? Reasonably not as long as it should take, because the police are aware of the 2 crimes that had happened, and because they're on the lookout for this, a warrant should have been able to easily be attained, especially because our client was being cooperative with the officer.
And so what information would have been conveyed that would justify getting a warrant that's different from what the officer knew, as far as whether there would have been probable cause to think that there was evidence in the car?
Well, then that's the question of whether or not the temporal proximity has the biggest effect, is whether or not the closeness between the stop and the evidence within would have played into it, because Officer Doe specifically did not know what was stolen. Other police officers did, and therefore a warrant, that would have been justification for a warrant. Officer Doe could not have acted in good faith if she did not know what was in the car, because she had no evidence to believe there was anything in the car. And so the lower court's decision should be reversed, because there's no clear sign that there's anything in the car. Thank you.
Chief Justice Muniz, honorable justices, and may it please the court. My name is Zoe Priolo for the petitioner, Jack Rogers, and today I will be discussing issue 2 on whether the security camera footage entered during trial was properly authenticated under the rules of the silent witness theory and section 90.901 of Florida statutes. We respectfully ask this court to reverse the decision of the 7th District Court of Appeals on the basis that the testimony given during the trial was not sufficient to authenticate this evidence under the silent witness theory, that the witnesses who gave that testimony did not have the knowledge that this was a fair and accurate copy of the video, and that this produced a harmful error.
What standard of review do you think we should apply?
Your Honor, this would be an abuse of discretion standard, as this is dealing with an evidentiary issue. Now, it's important.
So what does it mean for a judge to abuse his or her discretion?
This would mean that the judge would have improperly ruled based on the evidence that they were presented, and would have made a decision that another judge in their position would not have made. And
doesn't it mean that no judge in their position would make that determination?
Yes, Your Honor, that would be a bit of a clearer definition of that. And we would say that this was an abuse of discretion based on the clear facts that the criteria for the silent witness theory was not met through the testimony that was presented at trial. And this is specifically discussing about the criteria under Wagner v. State, which was a case decided in 1998 that determined the 5 criteria for the silent witness theory. And the criteria that we're missing specifically was criteria regarding the camera's reliability process, which is what the silent witness theory is asking for. Essentially, it's a way to authenticate this evidence by authenticating the process that created the evidence. And for this, we will have to, the state was tasked with showing that the cameras were authentic and that the preparation of this footage was also authentic. And here, we did not see any testimony to that. Specifically,
Go ahead.
What about the testimony that that Mark, don't have his last name, was using EasySafe for 10 years. They have technicians on call 24 hours a day. They respond to requests for video footage. He's used the same process to get the video that they have in every other case. Why isn't that sufficient to satisfy that prong?
Your Honor, that would not be sufficient, as it's not going towards the specific camera that was used to film this video. We don't know when the last time this camera was serviced. We don't know the maintenance of this camera. And essentially, we need to know that basic information and those basic facts in order to prove that this video was authentically created by that camera.
The standard comes from what?
The standard of the silent witness theory, Your Honor?
Right.
It comes from the case of Wagner v.
But
State.
isn't there a statute there's the 5 factors, but what's the ultimate kind of test that the 5 factors are directed to?
That goes to the statute 90.901, which essentially says that authentication is a requirement to admit evidence, and that in order to authenticate evidence, there has to be evidence presented that the evidence is what its proponent claims it to be.
Okay, and so anytime you have a multi-factor test like that, you can imagine that there's going to be some cases where, you know, some of the factors might be important than others. There may be reasons why you would kind of want extra reassurance that something's reliable. I mean, in this case, you know, given the time stamping and the quickness of getting the video and the fact that it aligned with what, you know, the witness, the second guy in particular, had seen, I mean, why isn't, if the question is ultimately, is this reliable? I mean, why wasn't there every reason to believe that it was?
There was not every reason to believe this was reliable for the simple fact that there was no testimony given to the preparation of this footage. We don't know the chain of custody. We don't know who had this footage and when they had it. We weren't able to cross-examine the person who had this footage from Easy Safe Camera Company. And under the decision of Carrillo v. Davis, it was ruled that we ought to have that opportunity. Now, there was an email correspondence that was presented, and it did contain the time that the footage was downloaded and the link to that video. However, we were not able to cross-examine an email. We're not able to ask the email if there was any sort of editing. And under that standard, we should be able to, and we ought to have been able to. And because we weren't able to talk to the people who created this footage, then that factor would not have been satisfied.
So give me what's a plausible scenario? What would I be? Give me like a plausible example of what I would be worried about, that I could be misled into thinking that this thing that I'm watching isn't reliable for such and such reason. What would that be?
That would look like minutes from the beginning or the end of that footage that could possibly be missing. It could be some sort of editing of events. I mean, if we're looking at this in a modern context, videos are edited all the time. If a video is placed on a computer, a phone, a tablet, videos can be created using artificial intelligence. And in a modern context, we need to have that information laid out during trial, because as this technology has been evolving, there's more of a danger of those types of situations happening where footage is created, footage is erased, and that's where the danger lies. It's in the potential situations of that. And because we didn't have any of the testimony regarding the people who prepared this video, the cameras themselves, we just don't have that knowledge to be able to authenticate a video. And under the silent witness...
On the flip side, though, there wasn't any affirmative evidence of tampering, right? There was nothing that a reasonable finder of fact could infer that there was tampering or editing or minutes cut or anything like that, correct?
Yes, Your Honor.
So how could we say that the trial court abused its discretion when presented with some evidence, certainly, on how the video was obtained and that it is what the proponent says it was? Why would we find the trial court was unreasonable in saying it was properly authenticated when there was no competing evidence?
Well, Your Honor, because the trial court abused its discretion because those questions should have been asked. The evidence should not have been allowed to enter until that was established, until we could establish what cameras created these videos, the preparation of these videos. It should not have been entered until we had that basic information that, once again, was just simply missing, especially because there were 2 separate videos that were entered. One of the first robbery, the second of the second robbery, but only one of the store owners, Robert Smith, was called to authenticate the videos. And on page 12 of the record, it was argued that because the events of the videos were similar, that you could authenticate the videos using just one of those individuals authenticating the camera types, and not that there was much testimony necessarily to those camera types. However, we can infer in this case, just because the events are similar does not mean that the cameras would have been similar. It doesn't mean that the person who prepared those 2 videos was the same individual. And it just means that we have to lay out that foundation for both of the videos in order for those to be authenticated. Additionally, the state of Florida has had a very well-established trend of what that testimony would have looked like. Under Dolan v. State, we see that in order to have authenticity of those cameras, there needed to be authenticity of the cameras involved, the way that it was prepared. Now, I see my time is running short, so it is for these reasons that we ask the court to reverse the decision of the 7th District Court of Appeals. Thank you.
Thank you very much.
Chief Justice Muniz, honorable justices, good afternoon, and may it please the court. My name is Katerin Fativ, and I, along with my co-counsel Jonathan Schwartz, have the pleasure of representing the respondent, the state of Florida, in this action. Of the two issues before the court today, I will be addressing issue 1 and demonstrating why this honorable court should affirm the decision of the lower court for the following 2 reasons. First, the search conducted by Officer Doe fell under the automobile exception, and secondly, the search also fell under the search incident to arrest exception. Now, the petitioner is overlooking one fundamental principle that the Supreme Court has upheld since 1925, and that is that it is absolutely undisputed in the record that at the time of the stop, the petitioner was in an operable and mobile vehicle. And the petitioner correctly pointed out Carroll because in Carroll, the Supreme Court specifically distinguished between the expectation of privacy one has on their person or in their home and the diminished expectation of privacy they have in a vehicle. And in Carroll, that expectation of privacy was so far reduced that upon having probable cause of there being evidence in the vehicle, officers were able to go as far as ripping the cushions from the seat of the car in pursuit of evidence.
So how do you get to probable cause in this case, though? Don't we need to start first with whether there was a legitimate stop?
Yes, Your Honor.
And if there's not a legitimate stop, there's no probable cause, right?
Correctly. And in the instant case, there was a legitimate stop under Wren. Although Officer Doe had stopped the petitioner for the traffic citations, at the time that she had stopped the vehicle, even if there was a pretext, she had probable cause of there being illegal tint, which is a valid traffic citation. However, at the time...
Is that clear from the record? Because it seems like the subjective reason for stopping the car, or the truck rather, was that it was the make, model, and dark tint, not make, model, and illegal tint.
Your Honor.
And
yes.
it was specifically because it matched a description and a crime. Is that enough to stop?
The fact that there was a pretext, namely the fact that Officer Doe thought that the vehicle might have had been involved in the robbery, is not of the matter in this case. Her subjective intent didn't matter because she also saw that there was a darker tint, which could have then amounted to an illegal tint for the traffic infraction. But in addition to that, at the time of the stop, once she saw that the vehicle had matched the description of the car from the robberies, namely she knew the make, model, tint, and year of the car. She also, at the time of the stop, knew a robbery had occurred a few days prior and that one had occurred just 2.5 hours before she stopped the car. And at that point, she might have had just reasonable suspicion. But at the moment that she went back to her car, got the bolo telling her the last 3 digits of the Chevy Silverado involved in the robberies, license plate numbers, and then when she was able to look up at the car that she had just stopped and see that R52 matched that car, that was when she had enough probable cause to believe that there would be evidence of the robberies in the car.
So I want to ask you. Go ahead. Well, I wanted to ask you about that because your colleague on the other side is suggesting that it's not enough just to have probable cause to think that this car was involved in the robberies, but that there's actually evidence, from the robberies in the car. Is he right about that?
The standard for an automobile exception search is that there's probable cause, meaning that it is reasonably probable that there would be evidence of the crime in the car. It doesn't have to be substantive. Probable cause isn't the same as beyond a reasonable doubt. Rather, it's just that probability.
But are you saying basically there's a rule? Is there basically just sort of a per se thing that if a vehicle is involved in a crime that it necessarily creates probable cause to think that evidence will be in the vehicle?
It's not necessarily, but if given the circumstances, given the totality of the facts, it would be probable, then that amounts to probable cause. And that can turn this court's attention to United States versus Ross. The Supreme Court in that case found probable cause for the automobile exception on similar grounds. There, officers had an informant's description of a car and a claim that a robbery would occur. However, they never saw the robbery occur. They simply saw that the car was in the same general vicinity, and upon confirming the description matched, they were able to search the car legally. And
well,
here,
I guess the question is, what's the exigency here? Rogers actually says he offers to call his dad. Yeah, there's the basketball tryout, but it's not like he's going to flee the scene for the basketball tryout. How do you answer your colleague's argument that there was no exigency here. There was plenty of time to go get a warrant.
Your Honor, as Justice Sasso pointed out, the justifications of the automobile exception are to be considered, and here officer safety is clearly an issue. Even dangerous people can be compliant in police encounters. And
Is there anything in the record to suggest that Officer Doe was threatened?
Certainly, Your Honor. Here, the crime was one that involved a gun. An individual had been shot with the gun, and the petitioner pointed out that here the plain view aspect was not important. However, the fact that Officer Doe, on page 4 of the record, the only item in her plain view was that black backpack, which, given the circumstances, very well could have had a weapon in it. And as for the petitioner's compliance, the fact that he was just simply outside of the vehicle did not reduce the risk that he could be harmful. For instance, in United States versus Thornton, the Supreme Court pointed out that an individual that has just stepped out of a vehicle, as opposed to somebody who's still in it, still poses the same risk, as they can still just as easily reach for weapons. Here, the petitioner had a reduced expectation of privacy. Officer Doe could have reasonably believed that she would find evidence of the robberies in the car, and more so, she had a concern for her own safety.
I think we're getting a little tangled up. She doesn't know, Officer Doe doesn't know to be concerned about her safety until after she sees the backpack, right?
That is correct, Your
I
Honor.
mean, when she sees the tint and and Justice Sasso has explored with you whether the tint was unlawful. She just knows it was dark and the vehicle matching the description. She doesn't at that point have a reason to fear for her safety, or does she?
Before she saw the backpack, she would probably not have reason to fear for her safety, but she saw the backpack prior to conducting the search, and and for an automobile search, all of the facts present to the officer beforehand are what are to be considered, and her plain view of the backpack was beforehand. And in addition to her having probable cause of there being evidence of the crime, she also had probable cause to arrest the petitioner. Here, the petitioner pointed out to the fact that whether or not the arrest had occurred prior or after, the standard does not change. And while she had arrested the petitioner after she searched the car, in New York versus Belton, as cited in Gant, the standard is that the arrest is contemporaneous. And in the instant case, the record reflects on page 5 that she had arrested the petitioner just moments after she had searched the car. Yes, Your Honor. All of the circumstances that gave her probable cause to search the vehicle, the respondent would argue that those were the same circumstances that would then give her probable cause to arrest the petitioner. And in addition to that, the temporal and the geographic proximity are to be considered. The record reflects that this car was stopped just 2.5 hours after the second stop in a small town in the same vicinity as the crimes. All of these circumstances are comparable to that of Strong versus State, for instance. There was probable cause to arrest the driver of the vehicle and thus lawfully search the car because the police relied upon an informant's description of a car and a GPS tracker showing that he was in the general proximity as the crime of the robbery. Here, like the GPS, Officer Doe was able to place the car with the last 3 digits of the license plate number and both the spatial and the temporal proximity. And so because she had probable cause to arrest the petitioner, the elements of Gant also have to be considered. And the petitioner misapplied the standard of Gant. Gant isn't an and analysis, it's an either or analysis. The two justifications of Gant are that there is officer safety concerns and that there is reasonable suspicion, not probable cause, of there being evidence of the crime in the car.
What's the difference
between reasonable suspicion and probable cause? Reasonable suspicion is more than just a hunch. It's just a little bit more than a mere suspicion. Probable cause is a reasonable probability of there being evidence in the car. Here, she certainly had reasonable suspicion based off the fact that the description of the car matched, and she certainly also had an officer safety concern, both because of the nature of the crime and the item that was in her plain view. And so because she had probable cause to arrest the petitioner before the search, and more so, she took steps to effectuate that arrest through not allowing him to leave, and because both of the justifications of Gant were met, we'd argue that the search incident to arrest exception also applies to the search. And lastly, because the search was well within the bounds of the Fourth Amendment for the two aforementioned exceptions, the exclusionary rule may not be invoked, as Officer Doe did exactly what she was necessitated to do under Carroll and under Gant. And therefore, for those aforementioned reasons, we respectfully ask that this honorable court affirm the decision of the lower court. Thank you.
Thank you.
Good afternoon, Chief Justice, honorable justices, and may it please the court. As previously introduced, my name is Jonathan Schwartz, and today I also have the pleasure of representing the respondent in this matter, the state of Florida. Of the two issues before the court, I will be addressing issue 2, which is whether the trial court improperly ruled that security camera videos were authenticated under Florida statute section 90.901 and the silent witness theory. Today, we ask this honorable court to affirm the decision of the lower court and confirm the conviction for the following 3 reasons. 1, the security camera videos were properly authenticated under the silent witness theory as articulated in Wagner v. State. 2, the security camera videos were also properly authenticated under the pictorial testimony theory. And 3, even if this court rules that the videos were not authenticated under either of the 2 theories, the trial court's error in authenticating the video was harmless. Now, the standard of review
Can we go to harmless error first? How is it possible that the error, if it was error, was harmless? I mean, isn't the video pretty powerful evidence linking Rogers and his co-conspirators to the scene of the crime? I mean, isn't it pretty important corroboration?
Justice Curiel, the reason it is harmless error is because all of them, in its most relevant form, the testimony can be supplanted by other forms of evidence in that the video itself establishes 3 things. First, the partial license plate, that being the last 3 digits R52. Second, the fact that a robbery did in fact occur. And lastly, that there were stolen goods from the store itself. And these 3 are met through other forms of testimony. Firstly, Mark Smith and Robert Smith testified to the fact that a robbery did in fact occur. They then testified to the stolen goods from their store. And lastly, Mark Smith, even without the video itself, was able to identify the last 3 digits of the license plate, that being the last 3 digits R52. Thus, since all the relevant parts of the video can be obtained through other mediums, the video itself, it would be harmless error if it wasn't to be admitted.
So why do you think the state introduced the video into evidence if it really didn't need to?
Your Honor, the state introduced the video into evidence simply because it would add to their testimonies. It would corroborate their testimonies.
So you admit that it was corroborative of their testimony?
It was corroborative, but the testimony could have been implied through other mediums, and as a result, it is harmless error. Now, the standard of review per Brooks v. State, as cited in Gos-Kaminsky v. State, is that the admissibility of evidence is within the sound discretion of the trial court, and the trial court's determination shall not be disturbed by appellate review absent a clear abuse of that discretion. On top of the petitioner's high burden in establishing an abuse of discretion, the state's burden in proving authenticity is extremely low. As per Lamb v. State, authenticity is ultimately a question for the fact finder, not the trial court. And all that's required is a prima facie showing of authenticity. And in the instant case, a prima facie showing of authenticity was made under both the silent witness theory and the pictorial testimony theory. Now,
given our modern AI, why this authentication?
Yes, Your Honor. Firstly, the authentication standard should not be strictly adhered to because it's a prima facie showing. And what this means is we have to make an initial showing the evidence is what it purports it to be. That being, we have to follow the statutory definitions as found in section 90.901. And as such, while there is a more modern context and a heightened risk of editing, by establishing sufficient evidence in the record, we produce a chain of custody that would reveal a lack of editing or tampering, which is found in the silent witness theory analysis in Wagner v. State. Now, the petitioner is correct in asserting that there is 5 evidentiary considerations as per Wagner v. State. However, we would like to remind this court that as per RV v. State, these factors are merely guiding factors and non-exhaustive. And the question before this court is whether there is ample evidence to support the lower court's determination that the evidence is what the state purports it to be. That being a robbery occurring at a stop and drive. And in the instant case, through the use of circumstantial evidence, as found in U.S. v. Broomfield, and as applied by this very court in Gos-Kaminsky v. State, there was ample circumstantial evidence to support the lower court's determination. Now, in RV versus State, there were two witnesses that authenticated the security camera footage. The first was a house employee who testified to the request from the camera company, and the second was an officer who interviewed the victim in the video and then determined that the two were substantially the same. And the holding in RV versus State applies for two reasons. Firstly, Mark Smith and Robert Smith, similar to the house employee, testified that to the request from Easy Safe as reflected on page 7 of the record. And secondly, Mark Smith and Robert Smith also testified that the three people involved in the robbery were the same three people depicted in the video evidence, similar to that of the officer. Thus, the court should find the holding in RV versus State extremely persuasive. As to the petitioner's assertion that an Easy Safe camera company technician was not called, we would like to direct this court's attention to Simmons versus State. Now, in Simmons versus State, the court opined that requiring a technician to testify would set the burden for authenticity too high. And in fact, a video can be authenticated based on its distinctive characteristics. And this is found in U.S. versus Broomfield. And as in U.S. versus Broomfield, there was positive identification of the defendant, the time and date was found on the video, and there was a specific identification of the rifle and ammunition in the video. And this is similar to the instant case for three reasons.
Should we be concerned that the officers burned a copy and labeled it themselves versus having something come from the company to show what the actual evidence admitted was?
No, Your Honor, there should not be a concern because we introduced Easy Safe camera company correspondence as reflected on page 12 of the record, and as a result, there is no inherent risk in trusting the officer's testimony. Now, regarding U.S. versus Broomfield, the reason it's similar to the instant case is for a multitude of reasons. For starters, the ammunition and rifle found in the video is similar to the stolen boxes and envelopes depicted in the video evidence. Furthermore, the positive identification of Broomfield is similar to the identification of the three robbers in the video. And lastly, as reflected on page 12 of the record, the time and date was found in the video. Thus, the court should follow the holding in U.S. versus Broomfield. Furthermore, the instant case is distinguishable from Cirillo, as in Cirillo there were strong concerns of editing, extremely strong concerns, and in the instant case there were no such concerns. Secondly, the video were also authenticated under the pictorial testimony theory. Now, as per Smiley versus State, as cited in RV versus State, any witness has the ability to testify to the foundational facts to authenticate a video under the pictorial testimony theory. That means an Easy Safe camera company technician need not be called in order to authenticate the video. And in the instant case, Mark Smith and Robert Smith have sufficient personal knowledge to testify to the authentication of the video, as they were able to corroborate the time and date of the video, and not to mention, they were able to identify the location itself, and Mark Smith and Robert Smith had a view of the outside, and they were able to testify that the 3 digits on the vehicle were R52, which Mark Smith was able to identify without the video itself. Based on the totality of these circumstances, they would also be able to authenticate the video evidence under the pictorial testimony theory. Now, I would also like to remind this court that Cirillo versus Davis is an extremely interesting case, as there's so much concerns of editing. On top of these, whereas in the instant case, a sufficient chain of custody was established. Firstly, Mark Smith and Robert Smith testified to the request from Easy Safe Camera Company. Secondly, the officers testified to the procedures from which they downloaded the footage from Easy Safe Camera Company. And lastly, the correspondence itself was introduced into trial. The reason that this holding in Cirillo versus Davis was so is because of the strong concerns of editing. Not to mention, the tape itself was only made for the purposes of litigation, and the video was selectively turned on and off. That is why they required a technician to testify, because of the multitude of circumstances that would put the video in such a risk. But in the instant case, none of these circumstances, contrary to what the petitioner asserts, are present. Now, before I conclude my argument, I would like to remind this court of one fundamental principle of authentication. As found in a wealth of case law, Goskaminski versus State, Lamb versus State, and Mullins versus State, authenticity is ultimately a question for the fact finder, not the trial court. And we have made out a prima facie case of authentication, as that is what the law requires. And the petitioner's attempts to overrule what the jury's ultimate responsibility is should not be upheld by this court.
But the trial court is still a sort of a gatekeeper, though, right?
Yes, Your Honor, under Daubert, they would be a gatekeeper. However, when it's the ultimate decision of authenticity is to the jury itself, the court should allow the jury to make that ultimate determination. That is why...
Does that mean the judge is supposed to sort of resolve doubts in favor of letting it in?
No, Your Honor. All is required is a prima facie case, and in the instant case, by RV versus State and U.S. versus Broomfield, a prima facie case was made out. I see my time has run out. May I briefly conclude?
Sure.
For these reasons, we ask this honorable court to affirm the decision of the lower court and confirm the conviction. Thank you.
Thank you very much.
I'd like to start by analyzing the two prongs in Gant that the opposing counsel specifically used to justify the probable cause. In the first prong, the officer safety prong, if Officer Doe truly was felt unsafe of the backpack in the vehicle, she clearly stood away from the vehicle, went back to her patrol car, and still did not arrest my client, even if she felt her safety was in danger. And so clearly this prong does not apply because Officer Doe showed no signs of feeling in danger. And specifically, they used Ross, opposing counsel used Ross to establish that probable cause is linked to a witness saying that the vehicle's description matches in a crime, so that's probable cause. When in reality, in Ross, the officers had probable cause because they saw a bullet on the passenger seat and then proceeded to search with open view exception. And specifically on the second issue, the use of RV State was incorrect because in that case they identified the defendant. In our case they did not, and we cannot reliably claim footage to be reliable if we do not know where it comes from. And so thank you, Your Honors.
Thank you very much. We'll be in recess for about 10 minutes and then we'll be back out. Thank you.
All rise. Honorable Court, recess. Florida Supreme Court is back in ceremonial session.
Thank you. On behalf of the court, I wanted to thank you for being here, and I wanted to give you just a little bit of feedback, all complimentary and positive. But before I do that, we were actually just curious and asking ourselves what grade you guys are in school. Sophomore, wow.
Happy birthday.
That's great. How about
That's
you?
sweet.
Okay, excellent. All right, well, we're all really proud of you. We thought you did a great job. The things that really stood out for us were, first of all, just how direct you all were in answering the questions, which is, a challenge for, advocates at every level. We thought you guys did a great job with that. We thought you did a great job with your ability to invoke authority to support the answers you were giving. And we thought that all of you did a good job of kind of weaving from, answering our questions to getting back to sort of the narrative thread of the points that you were trying to make. So, you should all be proud of yourselves. Whoever your coaches have been should be proud. I think whoever came up with the problem did a great job. A lot of times when we do these things, it's kind of lopsided in terms of the merits, which can make it very challenging for the advocates. And I thought that this one was, substantively, it was pretty evenly balanced, and there were good arguments on both sides. And so I thought it was kind of a fair fight in that way. Sometimes people do great, but it's, they're so obviously on the losing side of the case that it makes it hard for them. But I thought in this case, it was a very, very well put together set of questions, and each one of the two questions I thought was interesting, which sometimes you'll have two issues and one of them is a lot more interesting than the other. So this was great. So compliments to everybody involved with this, and we really appreciate it, and we're all very excited and hopeful for you guys. I hope you stay interested in this stuff, and those, if you do choose to go into a career in the law, I'm sure you're gonna be great. So I'd like to call upon Erica White to make some remarks, and then we'll close it out and make our announcements.
Good afternoon, justices, and to everyone. My name is C. Erica White, and on behalf of the Law-Related Education Committee and the Florida Bar, I extend our heartfelt thanks to everyone who made this year's competition a resounding success. First, our sincere gratitude goes to the First District Court of Appeal for hosting the semifinals and to the Florida Supreme Court for hosting this final round. We are deeply appreciative of the First District judges and Supreme Court justices who, despite their very demanding schedules, dedicated their time to provide our students with an enriching experience. We also want to thank all of the district judges from the 2nd through the 6th for their unwavering commitment in organizing the preliminary rounds. Without your support, advancing to the semifinals would not have been possible. Our thanks extend to the court staff statewide for assisting the Florida Bar with the competition logistics, ensuring everything ran smoothly. Additionally, we are grateful to the attorneys from the Law-Related Education Committee and the Florida Bar Appellate Practice Section. Your diligent grading of the extensive number of briefs and your adept facilitation of the virtual arguments were crucial to managing a competition that has more than doubled in size this year. Your collective efforts turned a daunting task into a seamless process. Above all, we commend the students who participated. Your hard work, evident in both your written briefs and oral arguments, elevated the quality of this competition to a standard comparable to that of seasoned legal professionals. We also extend our thanks to the school sponsors and attorney coaches for ensuring that each student was thoroughly prepared. Your support was instrumental in upholding the professionalism and decorum that defined the courts. We would like at this time to acknowledge the schools that advanced to the preliminary rounds this year. American Heritage High School, Palm Beach, Destin High School, Florida State University School, Ponte Vedra High School, Strawberry Crest High School, Fort Lauderdale High School, IT Prep Academy North, St. Thomas Aquinas High School, Lake Howell High School, Manassas High School, Orangewood Christian School. And we congratulate the schools that advanced to the semifinals. Taylor County High School, Perry, Florida. Bell Creek Academy, Riverview, Florida. Hialeah Gardens Senior High School, Hialeah Gardens, Florida. American Heritage High School, Broward Campus, Plantation, Florida. Beachside High School, St. John's, Florida. And Boone High School, Orlando, Florida. Thank you all once again for your dedication and hard work. We look forward to seeing you again at the 2026 competition, and I turn it back over to the Chief Justice.
Okay, thank you, Erica. All right, well, it was tough choices that we had, like I said, because everybody did so well. But we decided that the winning team is the respondents. And the best advocate is the birthday girl, Katerin. Okay, well, thank you. And I think now we'd like to get some pictures with you guys.
We're gonna